Human rights and equity in education. So this is a professional development workshop, and the goal of the workshop is to get through this particular agenda so that we can increase understanding about human rights and equity. So part one will be an introduction to human rights and equity, followed by part two, which is just a discussion about the Human Rights and Equity Advisory Office. Part three will go through human rights and equity in education, and then part four will be a question and answer period. The entire presentation shouldn't take us beyond 9:50 p.m., which is the time that we, or a.m. rather, which is the time that we have here together today. So, introduction to human rights and equity. The Ontario Human Rights Code is the prime piece of legislation here in Ontario as it relates to human rights. And so oftentimes there's a little bit of confusion about what the Ontario Human Rights Code really is. I mean, beyond the title, which is self-explanatory, but really, how does the Ontario Human Rights Code operate within the lens of all the other pieces of authorities like legislation, policies, procedures? How does it operate? Where does it sit? Well, to kind of, dispel some of that confusion and some of the misunderstandings around that, the Ontario Human Rights Code really is a prime piece of legislation. So as it relates to the Education Act, as it relates to Toronto Catholic District School Board policies and procedures, if there's ever any conflict or confusion as to which one to follow in a particular set of circumstances, it will always be the Ontario Human Rights Code, because that is the number one piece of legislation as it relates to interpreting and understanding other pieces of authorities in this area. So in terms of the code, the Ontario Human Rights Code provides for equality and freedom from discrimination in 5 protected social areas. So 1, housing; 2, goods, services, and facilities; 3, contracts; 4, unions and professional associations; and 5, employment. Now, because Toronto Catholic District School Boards is providing providing services and facilities rather to the students in which we serve, we do fall within this area right here, which is goods, services, and facilities. Now, if you are an employee, which I imagine you are if you're in this training session, then we also fall within the catchment area of employment as well. So out of these 5 protected social areas, when we are talking about Toronto Catholic District School Board, we are here with goods, services, and facilities, and here with employment. Now, this is really important because it means that the Ontario Human Rights Code applies to all members of the Toronto Catholic District School Board staff member. It applies to our stakeholders, and it applies to anyone who comes within, a relationship, so to speak, with the TCDSB as it is. And so let's kind of dive a little bit deeper into what that might mean. So there are protected grounds, and these protected grounds are within the code itself. There are 17 protected grounds, which is really just a fancy way of saying inherent characteristics that are protected by the code, that have legal protections through the Ontario Human Rights Code. So those are race, color, ethnic origin, ancestry, creed, place of origin, citizenship, marital status, disability, record of offenses, family status, age, sex, gender identity, gender expression, sexual orientation, and receipt of public assistance. Now, in the code itself, these are the areas that lawyers have litigated, individuals have found protections under whenever discrimination might happen, which we'll go into further details later as well. Important to note is that this list is forever changing. So society is always moving, it's changing. What might have been a social harm before or considered discriminatory, in the past might be even more discriminatory now. There are always areas that are kind of moving and changing. So for example, lawyers have kind of become aware of those changes in society, and we slowly move towards expanding these protected grounds. So a really interesting example that's making its way through the courts right now is whether or not weight discrimination should be a protected grounds. Arguments have been raised that, people are treated differently based on their BMI index. An individual who might be very heavy could be treated and mistreated, discriminated against, as opposed to someone who might be of a lesser BMI. And so that is something that might potentially find itself as perhaps the 18th protected ground. So what is discrimination? It involves one of the codified social areas, which we discussed earlier. So Toronto Catholic being in goods, services, facilities, or employment. And then it involves those codified grounds. So the 17 codified grounds that we discussed here. So if you've got that social area, you've got those codified grounds, and then there's some type of differential treatment. So say, for example, someone feels that they're being treated differently just because of their race or because of their sexual orientation, then we are now making a very clear-cut case to fit this legal formula, is what we call it, for discrimination. Now, discrimination in a nice definition is treating someone unfairly related to personal characteristics, the codified grounds, by either imposing a burden or denying a privilege, benefit, or opportunity enjoyed by others. So for example, imposing a burden might be, because the student is of Filipino heritage, they are required to, those students always have to clean up the class to the exclusion of all the other students. That would be imposing a burden. Now, say, for example, denying a privilege, benefit, or opportunity enjoyed by others. For example, something that we see here sometimes is, certain schools that are occupied by a certain, by the color of, that are not racialized, so by non-racialized individuals, having access to really wonderful programs like STEM programs and, really amazing visual arts type programs. And then denying that privilege, benefit, or opportunity that's enjoyed by those students for the STEM programs to racialized students who occupy more marginalized communities. That would be an example of discrimination based on this particular definition, which is also followed by the Ontario Human Rights Tribunal and the code itself. So discrimination can be either direct, it could be indirect, it could be subtle or unintentional. But really, when we're talking about discrimination, we're discussing impact rather than intention. So impact is, how did the individual feel impacted by what happened? It's never the intention of the individual. So say, for example, we hear often, but I didn't need to. It wasn't my intention to harm that person. I didn't know that I was making that person feel discriminated against or excluded. Those are common sentiments that we hear, but from a legal perspective, that is not a defense. That is not a appropriate response that is recognized in tribunals as it relates to trying to dismantle the claim for discrimination. Now, in terms of these 4 subtypes of discrimination, let's go through that a little bit. Direct discrimination is, pretty on its face. Like, it's clear it's discriminatory. You can see it for yourself. So for example, returning back to the example that I made earlier about the Filipino students imposing the burden that because they're Filipino students, they have to clean up the classroom after everybody. That would be a form of direct discrimination. Now, indirect discrimination could be something that kind of flows through one individual through another and then is impacted on the particular community. So for example, housing. Say, there's a lease out and the landlord tells the superintendent that they are not to lease that particular apartment to anyone who does not identify as white. If they are racialized, automatically they are not getting this lease. That would be an example of indirect discrimination because the superintendent is acting on the directions of the landlord to affect further discrimination. So in a case like that, the superintendent could be subject to a discrimination complaint as well as the actual landlord themselves. In terms of subtle discrimination, so this one's a little bit more difficult to determine. And it's very hard even for lawyers to also, make a successful case for within the tribunal. And subtle discrimination is something that we also see right now. So say, for example, let's use the housing example again. You've got beautiful set of buildings owned by company ABC. And those buildings, those residential buildings are in Forest Hill. Now, ABC also owns a bunch of residential buildings at Jane and Finch. Now, when you go to the Forest Hill rental buildings, they're gorgeous. They've got beautiful fountains. They have really nice, the grass is cut all the time. It's just a pristine property that very much matches the overall aesthetic of Forest Hill. Now, drive west of the city in Toronto, and you're in Jane and Finch. The exact same ABC company has a dilapidated building. Some of the doors are falling apart. It smells like urine. It's just a complete different environment, not suitable at all for humans to live in, for people to reside in. That would be an example of subtle discrimination because a certain population, so at Jane and Finch, the population is Black people, they live there. And so an argument could be made that, the property isn't being taken care of properly by this company that clearly has the resources to take care of the property. However, in Forest Hill, where it's, less occupied by Black people, it's a little bit, it's more white in nature. That's an example of that particular company subjecting the racialized community to discrimination, which is not experienced by the non-racialized community. So unintentional discrimination rather, is, kind of like what we discussed earlier. So this impact rather intention piece. So say, for example, if there's an organizational culture that seeks to kind of discriminate against or exclude a certain population, and, when confronted about this and told by the racialized member that they don't feel included, they feel like they're being oppressed in the sense of not being able to engage in, say, for example, commentary, customs, traditions that are relevant to them, but being forced into an organizational culture that is not inclusive. And they raise that. And then there's a continuance of that organizational culture without kind of seeking to dismantle it a bit. That could be a version of unintentional discrimination. So again, it's the impact that we're dealing with. We're never talking about the intention. So forms of discrimination, again, impact rather than intention is key, is harassment, poisoned environment, systemic discrimination, condonation, and reprisal. So harassment's pretty self-explanatory, and in the sense that, an individual feels like they're being targeted for reasons that are beyond their control. Poisoned environment could be an environment that upholds discrimination and that, actually celebrates it. So say, for example, somebody does something that's discriminatory to someone else, and the environment is poisoned, that individual ends up getting, the one who's harassing and discriminating against others ends up getting a promotion. That would be an example of kind of, further cementing discrimination as opposed to trying to dismantle it. In terms of systemic discrimination, we see that in education through the fact that Black students have, lesser outcomes, positive outcomes after going through our system than white students. And we see that through anecdotal evidence as well as through empirical evidence as well. Condonation, so seeing things happen, being aware of forms of discrimination occurring, and really just allowing it to flourish. No real form of, seeking to change that. And then reprisal. This one we see often with individuals who come forth about their discriminatory experience, and then they end up either losing their jobs, they end up experiencing, a toxic environment, a toxic workplace, because they came forward about their particular concerns. Systemic discrimination includes organizational culture. We can see it through numerical data, policy practices, and decision-making processes. So the role of the Human Rights Equity Advisory Office, which is the office that I am currently heading, we seek to remove systemic discrimination insofar as we can through reviewing policies, updating policies, removing that systemic discriminatory piece from those areas as much as we can. And I say as much as we can because oftentimes the issue isn't in how the policy or the procedure has been drafted. On its face, it's perfectly fine. It's fair, it's equal, it's great, but it's how it's applied. So for example, progressive discipline. We see progressive discipline on its face is fine. A student does something wrong today, maybe they get, don't do that again. We'll slap on the wrist, right? They do it again tomorrow. Okay, this is the second time you're here. Now it's time for maybe an essay. The third time, maybe community service. The fourth time, and we see kind of like a graduated approach up the pendulum of how serious the discipline might be. So that's how it should be. But now when we look at Black students, for example, we see a complete departure from that graduated approach and a direct line towards we're just going to suspend, or we're going to go to the top of the progressive discipline pendulum. And that is an example of systemic discrimination happening within the practice and within the decision-making processes, which is a lot more difficult to dismantle than it is through policies. Numerical data, the Anti-Racism Act recently legislated that our school boards would have to collect identity-based data about our students. And so we did that. Toronto Catholic is actually ahead of the curve because our data collection project has actually been performed and executed last school year. And so we are currently disaggregating the data, trying to understand what that means about our student population. Organizational culture is also here, a Eurocentric ideal of living, working, playing, exists at Toronto Catholic District School Board. And that is a form of systemic discrimination to those who do not identify from Eurocentric backgrounds. And so this is something that we seek to hopefully dismantle as well as it relates to systemic discrimination. So just this little nugget here, Ontario Human Rights Commission's policy and guidelines on racism and racial discrimination identify these three considerations for assessing and really characterizing systemic discrimination. So the Human Rights Tribunal, when all of these things are happening, the code has been infringed, there's a toxic environment, reprisal, condemnation, all the things that I just mentioned. Well, where do we enforce this particular law? Well, the area that the tribunal that we use is the Ontario Human Rights Tribunal, to really ensure that the Ontario Human Rights Code is being respected, and when it's being infringed, that the right repercussions legally are taking place. And so the Human Rights Tribunal really can only consider an application if two things are present. So one, it falls within the scope of the grounds, so the 17 grounds that we discussed earlier. That's a very important piece. So if somebody says, I feel like I was discriminated against today because I was wearing, leopard print glasses, and everybody likes to wear black glasses. I'm being a little frivolous here, but that wouldn't necessarily apply just because it's not one of the codified grounds, right? So the other piece to this is number two, having legal authority, so the jurisdiction to deal with it. Now, if an incident happens outside of the parameters of Ontario, then the Ontario Human Rights Tribunal, it doesn't apply. The Ontario Human Rights Tribunal really only deals with the Ontario Human Rights Code, and any other piece of legislation that is not the Ontario Human Rights Code does not come to the HRTO. Now, the other provinces have their own versions of these, of their own human rights codes. So BC has one, Quebec, all those different places. And then there's also a global overarching Canadian Human Rights Act that operates at the federal level. So the Ontario Human Rights Code, when can they not consider an application? Well, like I mentioned earlier, if the application doesn't relate to any of the 17 grounds of discrimination, or to an area. So for example, housing or employment. Now, that last section of the Ontario Human Rights Application Code not hearing an application, it would never apply to TCDSB because again, we are a goods, services, and facilities, and we also offer employment. So TCDSB will always be within the jurisdiction of the Ontario Human Rights Tribunal based on that piece. Two, the events have no connection with Ontario. Three, the human rights claim is before the courts are the subject of a court decision. So the tribunal doesn't deal with double jeopardy. There is no double hearings or double processes as it relates to human rights claims. If there is something happening in the civil system, that has to kind of resolve itself before it can come towards the Ontario Human Rights Tribunal. And the other area that the tribunal will not hear an application is if the respondent, so this is the person responding to the discriminatory claim, is a chartered bank, airline, television or radio station, telephone company, a company that operates buses and railways that travel between provinces, or is another company that is subject to federal laws. So returning back to the discussion about the Canadian Human Rights Act, there's also a Canadian Human Rights Tribunal who will hear anything to do with the federal instances of human rights infractions. So the tribunal has a limitation period of 1 year, which means if something happens today, that individual, the applicant, has 1 year from today to bring their claim before the Human Rights Tribunal. Now, if they go over a year, it means the limitation period has passed, but it doesn't mean that they can no longer bring the claim, period. All it means is that a motion will have to be made. So really it's just a document, a type of argument that will have to be made to explain why that individual needed more than a year to bring their claim forth before the tribunal. If the individual was discriminated against more than once, then the application must be filed within 1 year of the last event. So sometimes we see people who have been working for the organization for the last 15, 20 years, and they, never brought a claim, but they've been subjected to discrimination for the last 15 to 20 years. Well, we don't go to the first time that it ever happened and start that clock from 15, 20 years ago. We go to the very last time it happened. So if an individual is in a toxic environment, they are constantly experiencing discrimination, then what will happen is that the date moves forward along with each event, each instance of discrimination, pushing that limitation period further and further out. So timelines. These are pre-COVID timelines. COVID has absolutely destroyed the timelines and the processes in all of our tribunals and courts here in Ontario. But mediation is typically scheduled for about 5 months from the date the parties agree to it. Mediation is strongly encouraged at the tribunal just because, again, the system is overrun, it's over capacity as it relates to cases. And so if a hearing on the merits of the application is indeed needed, it will generally be scheduled to take place within 6 months from the date the application is ready to proceed to hearing. In some cases, and COVID being one of those, it can take much longer to hold a mediation or hearing. So this process is very long-winded in nature. And so because it's long-winded in nature, we really do appreciate having things like the Human Rights and Equity Advisory Office to help parties see where a tribunal might land on the issues and to avoid going through that entire process that could take 9, 10 years to resolve. Now, of course, the Human Rights and Equity Advisory Office can't offer remedies, financial remedies, but anything short of financial remedies is usually on the table to play with. So things like an apology, training sessions, perhaps accommodations so that the two individuals who are at conflict with each other are no longer working within the same environment, those types of things. So for those who do want to utilize the Human Rights Tribunal process, they've exhausted their internal processes, which the tribunal does encourage individuals to take advantage of, then they can absolutely take advantage of the Human Rights Legal Support Center to get assistance. Now, the tribunal is meant to be a people's court. You do not have to have a lawyer representing you for that. However, because the case law can be confusing, because there is a lot of jargon, it is encouraged that either individuals seek the support of the Human Rights Legal Support Center, which provides free services throughout the province and is independent of the Human Rights Tribunal. So sometimes people think that the Human Rights Legal Support Center and the tribunal are together and connected as one. They are not. Utilizing the services of the HRLSC does not mean that it will lead to a more positive outcome at the HRTO. They're not connected, they're totally distinct. And so another avenue that one could take advantage of is getting help from other legal clinics, a private lawyer, maybe even a paralegal, or even choosing to file that application on your own. Now, access to a paralegal is great because typically paralegal fees are a lot cheaper than lawyers. And so this is a really great way to kind of cut down on what could potentially be a very expensive process. So the Human Rights and Equity Advisory Office, which we spoke about a little bit, obviously the Human Rights and Equity Advisory Office the role is really to provide independent, impartial, unbiased, confidential support through consultations, training sessions just like this, mediation, and other services as appropriate. The HRA office is tasked with advancing human rights within the TCDSB proactively by developing and maintaining equity-infused policies, programs, services, and functions. So what is the HREA complaint process? The office is currently expanding. Within the department is, of course, myself, as well as our supervisor of student outreach and school support. Her name is Maria Jude. And we are currently in the process of hiring for an administrative officer, which the date of that position closes November 22nd. But in terms of this formalized process, we really are loosely developed around the Ontario Human Rights Code, which is supreme and which we must follow. So the social area being education, we're within that, the grounds that we mentioned, the 17 to 18 grounds, and then there's a complaint. If there is a complaint that matches these two pieces, then we're now in the human rights complaints process here at the TCDSB. So if there is a classroom concern by a student or about a student, then it will go to the contact teacher. That will then go to the principal, which will then go to the appropriate superintendent. If that particular concern is still not resolved, then it will go to the HREA. So you see kind of like a graduated approach. There are several different stages before it becomes an HREA concern. If the teacher isn't able to resolve, then we go to the principal. If they're not able to resolve, then the appropriate superintendent. And if still no resolution, then the HREA. Now, if the HREA can't resolve it, then that's when there's access to the pieces that I mentioned earlier, being the tribunal, Human Rights Legal Support Center, legal aid clinics, those kinds of things. So the external consultation and other processes available, those are those pieces there. Now, if there's a school concern about a student, student teacher, EA, student staff member, that goes directly to the contact principal, who will then contact their superintendent, who will then reach out to the HRA office. All school-related concerns within the school community must be dealt with by the contact principal. And again, we kind of flow through accordingly. All substantive human rights complaints across the board about community trustees come through the HRA office, and then we, talk about those external resources again. So, here at every single stage of trying to resolve these processes, the HREA office is always available for consultation. So while the HREA office may not take the complaint directly, the HREA office is available for consultation to help resolve these particular pieces. So why do we need an HREA office? Organizational responsibility demands that, and from the Ministry of Education, we do have organizational responsibility in these different ways. So organizations must take steps to prevent and respond to discrimination by appropriately responding to human rights complaints and concerns, not condoning, ignoring, or continuing any discriminatory acts, designing, our facilities and our areas, our publicly used areas in inclusive ways. So a great example of this is having gender neutral washrooms. That's something that the Ministry of Education is emboldened to the Ontario Human Rights Code to ensure that they are not infringing to us LGBTQ community rights. And so having gender neutral washrooms is actually a mandatory piece that we are starting to see more and more of throughout society. You go to the mall, you might see a gender neutral washroom in the newer wings, that sort of a thing. So those are not just great things to have, those are actually legally required as per the Ontario Human Rights Code. Identifying rules, policies, requirements, procedures that may be creating barriers, that's another organizational responsibility. Accommodating needs related to codified grounds and removing barriers to equality of outcomes. So organizational responsibility includes these three things. There is liability for the actions or inaction of employees and management. Organizations are required to provide an inclusive environment that is free from discrimination and harassment. And organizations are obligated to respond appropriately when discrimination or harassment occurs, such as taking progressive measures and sanctions for repeated behaviors, creating remedies to address impact on the environment, and then also working towards systemic remedies to prevent recurrence. Human rights and equity in education. Research shows us that disparities in educational experiences and outcomes are actually worsening for many vulnerable groups. Persistent concerns of harassment and discrimination have been raised by Indigenous, Black, racialized, 2S LGBTQ communities, people with disabilities, and others. So we'll notice that these particular communities are actually the ones who have been identified in those 17 codified grounds. Anti-Black racism in education continues to be a major problem, and this is prejudice, attitudes, beliefs, stereotyping, and discrimination that is directed at people of African descent. Anti-Black racism manifests itself as unequal opportunities, reduced experiences of well-being, which actually have physical health impacts as well on racialized people, overrepresentation in school discipline, like I mentioned earlier, where one departs from progressive discipline and speed lines over to the highest form of punitive measures for student misconduct, overrepresentation in special education, so really an under expectation for racialized students, particularly Black students, in terms of their abilities to achieve academic excellence, to achieve positive, excellent outcomes once they leave TCDSB, those types of things, and then disproportionately low academic achievement. So the failure to recognize and to actually provide resources to those Black students who might be suffering or who might, just need a little bit more attention in those classes. We see a denial across the system for assisting Black students in the ways that white students are assisted with their educational outcomes. So confronting anti-Black racism in education, educators must ensure they are not participating in, condoning, or allowing racial discrimination or harassment to occur. And the Ontario College of Teachers Standards of Practice demands this through the commitment to students and student learning, and then leadership and learning communities. So those standards of practices are available by the OCT, and they're there to govern educators accordingly. A human rights approach to education ensures that every student's right to education is respected and realized. It applies the rights and values set out in the Human Rights Code, not the HRTO, but the HRTO as well, if a matter falls within or comes forth before the tribunal. This approach supports the creation of inclusive environments that prevent and respond to discrimination. It understands the weight of the Human Rights Code over other laws in the province. So again, that primacy that I mentioned. It honors Canada's commitment to the values of the International Human Rights Agreement. So we're talking about United Nations type agreements, and acknowledges the overlapping interdependent relationship between equity and human rights. The primacy of the code. So I just wanted to include this nice little flow chart because I think it helps to digest the information a little bit more. But Ontario's Human Rights Code has supremacy over the Education Act, which has supremacy over the Education Act regulations, any policy program memorandas, and then school board policies. So as you can see, if any one of these are in conflict with the Ontario Human Rights Code, these provisions, these particular policies, procedures, authorities will have to be struck down and reinterpreted so that it is in alignment with the Ontario Human Rights Code. So there really is no debate as it relates to the Ontario Human Rights Code. That is the law of the province, which is supported by the law of the land through the Canadian Charter of Rights and Freedoms.
Hi, Lavinia, just a 10-minute warning.
Yep, perfect. Thank you so much. Why is the human rights approach critical? It fosters a culture that upholds human rights and meets the obligation to address discrimination and barriers, and also increasing inclusion. It also systemically addresses and prevents human rights concerns, supports staff and students' rights to equality of experience and outcome, enables all to reach their full potential, which is what we want for a thriving and successful society. It fosters the well-being of all students and creates a more just society. The human rights approach is critical because it also applies the HRTO principles of inherent dignity and worth, equal rights and opportunity, freedom from discrimination, culture of understanding and mutual respect, and that each person is included and able to participate fully. And so we've got about 9 minutes left. We can engage in a Q&A if there are any questions about that presentation.